Hi guys, today I would like to talk about 10 most asked questions in my business. Question number 1, what is the difference between contested and uncontested divorce? The simple answer is, in uncontested divorce, as the word suggests, the other side is not fighting it, is agreeing with it, with the terms, and there is no court appearance needed, which means in uncontested divorce, you will file for divorce. The other side may respond, may not, but the main thing is that both parties have an agreement. So that's informal term of having agreement. There is a default divorce when the other side doesn't file for response, which I don't want to go into the details of that, but general term uncontested means no objections to the divorce. Question number 2, how do I file for divorce? In California, and I can speak for the Bay Area, there are 2 main forms you need to file, FL100 and FL110, and some counties require so-called ADR form, arbitration form 11.17. Then you file it with your local family court. If you Google Superior Court of your county family, then you will find the address. Then you go, you file, and then you bring 3 copies. The court keeps 1, you get 2, 1 for the other side to serve, which then you hire someone over 18 other than you. Question number 3, how long does the divorce process take? That's the most common question, and I figure out the formula. It's like a pregnancy, 9 months. It can be longer, it can be shorter. It depends on contested, uncontested, how much court involvement is needed. Court schedule is very sporadic. It's hard to get a court hearing when you want it. A trial date sometimes takes a whole year to get in some counties. So watch out for that. If you have an uncontested divorce, count on at least on average on 6 months. Number 4, can I get alimony and how is it determined? I have a whole new video that is like 10 minutes long explaining alimony length, amount. I'm not going to go into a very detailed explanation about alimony, but typically alimony is granted temporarily to the party who is in need of money to maintain the standard of living of the marriage so that the other side can survive during the divorce process, called temporary support. And then long-term support is to maintain the standard of living during the marriage. And typically, if the marriage is under 10 years, the length of support is half of the length of the marriage. So if the marriage is 8 years, then support length is 4 years. And then in order to determine the amount of support, just calculate it, go to Google and type in child support calculate, child support, not spelled, child support calculator California, and at the bottom of that child support calculator, the page ending with GOV, which is the official website for child support calculator, you just uncheck the no to spousal support and yes, click your county, and then it will calculate the spousal support even though you don't have children. Question number 5, how is child custody determined? Typically, child custody is determined if both parents are present and fit, determined legal, joint, meaning who makes a decision for the children, physical, where the child is primarily residing for the purposes of registering to kindergarten, school, also 50-50, and then custody is different than schedule. Then the parent who is not residing with the child will get a schedule. Could be 2-2-3 or every other weekend depending on the situation. Question number 6, how much will child support be and how is it calculated? Again, if you go to the website, Child Support Calculator California, ending with GOV, then you will see there are 2 factors, income of both parties and the percentage of visitation. That's 2 factors to calculate child support. When you go to that website, you can see, if you don't know the schedule, click advanced and then see every other weekend will turn into 33% to the other parent. And then when you put in salaries, you put gross W-2 salary, monthly amounts, and then click calculate and it will produce child support. Question number 7, can the terms of divorce decree be changed after the divorce is final? So that's a tricky question. If you have a final divorce decree, then no, you cannot change unless you find omitted asset that wasn't part of the decree. Child custody can be changed if there is a significant change in circumstances. So anything related to a child can be changed. Support, the custody, visitation, money pieces are not changeable. So be sure before you sign off on the final paperwork of your divorce to consult an attorney and make sure that you completely understand the picture of what you're signing, because that's going to be final. And if you owe money and you don't pay, 10% interest will accrue on an annual basis. Question number 8. What is the difference between legal separation and divorce? Great question. Divorce requires residency requirement, meaning in county, the person who files for divorce needs to be living for at least 3 months preceding to the divorce, and in California for 6 months. For legal separation, you do not need that. All you need is to be present, or actually you don't need any residency requirement. You don't even need to be present. You can file for legal separation, but obviously in order to serve the other party and have jurisdiction over the other party, both people need to be in California so that the court has jurisdiction over the divorce. And then the reason why people file for legal separation versus divorce, they want to keep their health insurance ongoing. They don't want a divorce for legal, meaning for religious reasons, or the residency requirement is not met. That's the typical 3 reasons. Question number 9. How is property divided in divorce? 50-50 if it was accumulated between date of marriage and date of separation. That's a short answer. Question number 10. What is considered marital property and separate property? Marital property is property acquired through personal skills and effort between the date of marriage until the date of separation. So anything before date of marriage, anything after date of separation is considered separate property. Now, there are exceptions. So let's say someone brings separate property into community and that separate property needs to be managed. It could be rental property. It could be day trading. It could be anything that requires one spouse who brought it in to put personal effort. That's the exception where separate property is not 100% community, because the spouse is putting effort into that separate property. There are formulas, Pierre, Van Camp, different formulas that accountants will use to determine the percentage of community property on that separate piece of property. I hope that was helpful. That was part 1. There are 10 more other questions coming up, but I don't want this video to be too long. If you like this video, click like, subscribe, comment down below, and I will see you in my next consultation. Bye!